Hello, I'm Bill Peterson, a Minnesota probate and estate planning attorney. Oftentimes my clients will ask why some of the procedures in probate and inheritance law seem complicated and sometimes even old-fashioned. The truth of the matter is that many of these procedures follow the English common law precedents from the 13th century. You've probably heard of the Magna Carta, or Great Charter, that the English barons got King John to sign in the year 1215. When we were in school, we were taught that the motivation of the English nobles was a high-minded demand for trial by jury, due process of law, representative government, and other civil rights now contained in our Constitution. Not so. The demands for civil rights were largely an afterthought to what the nobles were really after, namely inheritance rights. To understand what the Magna Carta was really all about, we need to turn back the calendar to the year 1215. First of all, the lifespan of most people was truly nasty, brutish, and short, as the philosopher Thomas Hobbes was later to say. Life expectancy was about 39 years of age, and many men would never survive to see their children grow up. Likewise, women had a short life expectancy, especially since childbirth was often fatal. Moreover, women had few legal rights, except through their husbands or fathers. As a result, there were many widows and orphans in the 1200s in England. King John was constantly short of money. To get funds, he would take over the estates and inheritances of the families of deceased barons. The barons understandably wanted to preserve their family estates, and they didn't want the king interfering with their families. Some of the barons had been denied their inheritances from their fathers because of King John. Other barons were afraid that their wives and children would be left destitute if King John's seizure of estates wasn't stopped. As a result, they rebelled against King John and forced him to sign the Magna Carta on Runnymede Field near Oxford on June 15th in the year 1215. The Magna Carta contains 63 sections. After the introduction, the next 7 sections all deal with inheritance and estate issues. That certainly showed what the barons considered most important. Overall, 16 sections of the Magna Carta deal with family, estate, and inheritance rights. The civil rights sections don't appear until later in the document, so those rights were obviously less urgent to the barons. So the next time you wonder about probate or inheritance rights, you'll understand why I say, well, it all began with the Magna Carta.